concept of equal protection that comes in through as we just keep relaying the idea of teaching, good teaching altogether. So with that, I want to introduce our next presenter. And Christopher Riano is the president of the Center for Civic Education and a lecturer of constitutional law and government at Columbia University. He has served as a speaker and author at dozens of conferences and in several publications on multiple parts of constitutional theory. His latest book, The Marriage Equality from Outlaws to In-Laws, was just published last month, and it tells the story of marriage equality movement in the late 20th to early 21st centuries. Previously, Mr. Riano has served as the assistant counsel to the governor of New York for education, arts, and constitutional law. He's also been the general counsel for New York State Liquor Authority and an administrative law judge for New York State. So to help us understand the 14th Amendment and the Equal Protection Clause, Indiana Bar Foundation is pleased to have Christopher Riano.
Hey, everybody. Thank you so much. That introduction was so wonderful. Tim, I'm very grateful to be here. Thank you. And I'm really excited to have a chance to join everybody today. Tim and I were just discussing actually a few minutes ago how much I would much prefer to be able to do events just like this all day long than some of the other things that I have to do in my new role at the Center for Civic Education. I think I'm very excited to have even just the few minutes that we have together to talk about the 14th Amendment, and even before that to talk about some of the theories that underlie and underpin the law more generally. I'm going to open this up right from the get-go and note that I think it's really important to make sure that this is interactive. I think one of the benefits that I've always had as a law professor is I tend to be quite Socratic, but soft Socratic, and I like to ask a lot of questions. So please, please, please do not hesitate, because we're going to talk about some interesting things. Do not hesitate to ask questions in the chat. Even if it doesn't seem completely tied in, I assure you, that makes things more interesting, that makes things more exciting, and there's not too much that I probably can't get down and figure out and begin answering, at least in some capacity. I am going to share a PowerPoint in just a minute. I've tried very hard to essentially condense 2 full courses that I teach into about 60 minutes. Everybody on the Zoom appreciates how impossible that is. So if I miss something or if something gets lost in translation, raise your hand, throw it in the chat. I'm watching the chat as live as we all sit here talking. And I'm going to try to answer questions live. You don't have to save them to the end. That'll make this that much more exciting and that much more engaging. So with that, as I, like all of us have, try to get used to still using Zoom, because we all are getting used to this. I want to really focus on, at least for today, looking at, like I said, this larger question of what this looks like with the law and what the law looks like when it comes to the 14th Amendment. Now, I'm already going to ask a question right from the get-go. Is anybody aware, or does anybody know who this quote is from? Does anybody know who this quote is from? Here's the good news. Any guess is probably better than no guess, because it's not necessarily easy. I'm assuming that people know that this is written on the top of the Supreme Court. But is anybody who actually stated this? I'll give everyone a hint, and if anybody wants, I'm looking at the chat as we all sit here. It is a justice, so that should give everybody at least a step in the right direction. This justice is, I love that. So Andrea, I appreciate that guess. It sounds like her, doesn't it? It sounds just like her. That's who I would have guessed too. So Andrea, I appreciate that guess. John Marshall from Janet, you know what? That's also a very good guess. I wouldn't have thought of that. That's a very good guess. Oh, obviously, Jay, Thurgood Marshall. Okay, good. This is exactly why I wanted to try this out. So these guesses are phenomenal. This is perfect. think about this, because this sounds like everybody that everyone's just talked about. Equal justice under law is not merely in the facade of the Supreme Court building. It's perhaps one of the most inspiring ideals of our society, and it discusses really why law exists, right? It's a fundamental. It's an idea that justice should be the same in substance and availability without regard to economic status, right? So it sounds like Cardozo too. That's a great guess. And here's why I think this is surprising. It's because it's actually Justice Powell. I would never, ever have guessed this if I didn't look this up. So everybody would get 5 points because I certainly would never have figured this one out. And the reason I want to start with that is because I think that helps set a little bit of the tone and a little bit of the background as to why the study of law, and in particular, the 14th Amendment. We're going to talk about the Fifth Amendment and the 14th Amendment. But the Fifth Amendment, the 14th Amendment and the Equal Protection Clause is so unique. There's something very special about this. And I know that we all know this because we've all talked about this at some point or another, whether it's with our students or it's with our friends when things come up in society. This is one that everybody's always thinking about and discussing. So it's why I'm so excited to have a chance to talk to everybody about it today. Now, I'm gonna ask a really seemingly easy question, but don't be too surprised how complicated this actually could be. I'm curious to know what everybody thinks the law actually is. So what is the law? And here's a good thing. Unlike the last time, you cannot possibly get this one wrong. It's not possible, so that's a hint. But I'm curious to know what people actually think the law is. What is this thing that we constantly refer to? And as an attorney, I've obviously worked in this area, but you do not need to be an attorney to know and to think about what the law is. So what do people think the law actually is from your perspective? Man's attempt to keep order. I love that answer. That's absolutely correct because, in part, the law must be a descriptor and description of some sort of code of relationships, right? Some way of thinking about how we relate to one another. Andrea says the law is the body of rules that govern society. Absolutely, right? So it's thinking about this code, these relationships, these concepts, and how that forms that structure that governs the way in which those relationships look. The rules we have to follow. Yes, actually, I like that answer because it's both easy to understand, but absolutely correct. That's something a student would say, right? The rules we have to follow. And you think to yourself, yeah, of course, that's the law, right? There are rules that we all have to follow because we've agreed in some way to follow them. Standards we choose to live by and order our society. Wonderful answer, absolutely true. I like the concept and the use of the word choice. That's great because choice becomes really important in constitutional theory, especially. Statutes passed by states, look, absolutely. Jill, I want to be very clear. You'll see in a second, there's no question that part of the law comes down not just to constitutional theory, but statutes. Yes. Laws exist in households. Catherine, you're right about that. That's a really tricky one, and I love that. There is no question that rules and laws exist in many different scenarios and circumstances, and that includes households and other areas. Let me give an example of how that works in a way that you might not realize. When a judge walks into a courtroom, everybody stands up, right? There's no written law that says everybody stands up. There's no written rule that says everybody stands up. It's what we call custom. It's customary that people act that way. And yet it is baked into the system to the point where it's essentially a rule. It's something that everybody follows. It's something that I'm sure we've all seen at one point or another with students. I've always been so impressed with when I don't assign a seating chart in class, and yet all of my students are always in the same chairs in class. And they don't even realize that, but that's a structure. It's an order that they've even assumed. So I love that answer. And written agreed upon norms and rules for those who do not follow them. I actually really like the answer. So there's absolutely something about the process of writing. There's something really unique about the question about how you follow a law or not. And I want to note this too, as I know we're all aware, not all laws are written. So even like we were just talking a second ago, there's no written command to stand when the judge walks in, but everyone does it. There's no written constitution the way we think of it in the United Kingdom, but there's a constitution of the United Kingdom. So the piece and concept of writing is really important. I want us to keep that in mind. I am about to give us a whole entire course in one slide. So here we go. Hold on. So there are basically three major theories that are all tied together, and I'll show everybody in a second, that help describe and help us understand what the law is. Now, if you think back many, many, many years ago, and you think back before the Constitution was written, back when you have some very early legal philosophers, people that are thinking about, well, how do these relationships look? You have the first grouping around, and we still hear about this today, right? We have people that still assert and argue that there are natural laws and natural rights. The idea that certain things just exist, that there's nothing that we can do about it, that they exist because of the rule of essentially the state of nature. And a typical natural lawyer would say it is related also to this idea that if you just sit there and think and think and think, you will come up with better and better attenuations of what this natural law and natural order should be. And with that, I want to put a very important note. This is also where you would come up with concepts of natural rights. And what do I mean by that? So we would normally nowadays think of that as human rights, but it's this idea that there are some non-negotiables. There are some assumed responsibilities and assumed rights and assumed liberties that we all have that are natural, that are ours just by being alive. And I think that's important to note because as we go through our theory here, you're going to see how this translates to the amendments we're going to talk about later. Now here's the one that everybody was talking about. The fancy term that is often used is this idea of positive law and legal positivism. Let me just tell you what that is. It's actually much simpler than that. It just means the positive creation of a law, the passing of a statute, the adoption of a constitution, and even that customary topic we talked about before, right? So if custom becomes something that's followed over time, positively created by man, by humans, right? Then you have this positive creation of law that we've decided to create, we've decided to adopt, and we can also decide to change. This is a really important innovation when it comes to constitutional theory and jurisprudence. And I want us to be mindful of this as well as we keep on our journey, because there's one last thing that we have to be conscious of, and that's legal realism. Now, what is legal realism? Well, I think we can all think about how that looks. And let me give an example of legal realism. The reality is you can be in front of the same judge at some point in the week and receive a different result than you were in front of that same judge at a different point of the week. Why? Because there's a reality to how this works. There has to be a concept of reality to how this works. Different people feel differently about different words. Different judges feel differently about different facts. So there is a realism baked in to the system that I think we have to be conscious of. And that realism actually helps us tie all the way back to the beginning, because it helps us understand why we have such an attachment to human rights and natural rights. I want to give a few quotes here, just so that everybody can kind of see in the larger sense how this is looked at. And I did give Tim this PowerPoint, so you'll all have access to it. And yes, I'm trying very hard. This is an entire course in law school, but I'm doing this because it's really important. Why? Because how often do we think to ourselves, well, what is the law and how does the law work? And why did that happen on TV? And why is the news reporting that? And how does that work in the way in which government operates and the branches operate? And what's incredible, what is just shockingly amazing, is that the more you think about it, the more we all think about it, the more we all come to an understanding of how these pieces all interplay each other, the more we can come to an understanding of what the law is. And especially when one of our students or one of our colleagues or one of our friends or one of our family members comes to us and says, well, doesn't the First Amendment talk about free speech? Or doesn't the Fourth Amendment say that you can't have a search or a seizure without a warrant? Or doesn't the 14th Amendment have equal protection of the laws? We can come back to an understanding of, yes, the 14th Amendment says equal protection of the laws. That's legal positivism. We created it. I'm going to talk about that in a little bit. But the realism is, what does a judge thinks that looks like? And what are the facts in the case? And particularly when it comes to these big constitutional concepts like life and liberty and rights and things that we all love to talk about in constitutional land, natural rights, human rights, natural law becomes really important, because there are certain things that people feel very strongly about being just the way that they are. We'll talk about substantive due process, but being just the way that they are because they are so fundamental to our understanding of what should be just, what should be correct, what should be the way that we assume and expect things to look like. So before I go further, are there any initial questions or any comments on this as I very quickly go through what the law is? And we'll dig into this more. But I just want to make sure that we feel pretty comfortable, at least a little bit, with this. This is one of those things that sinks in over time. And it'll be 4 days from now, and you'll say, oh my goodness, that's right. Like, you'll see something and it'll click in your mind. That's how it's always worked when I've looked at this. Well, why does this become important? Why is it important to have an understanding of broadly jurisprudence and broadly the theory of law and broadly how this impacts the way we look at fundamental rights and fundamental liberties? Well, my PowerPoint. When it comes to understanding some of these fundamentals, it is natural when it comes to trying to look at the law for us to want to act actually in the wrong direction. What do I mean? To zoom in, to say, well, the facts of the case say this, and this is exactly what happened. And you and I, we all know what students do, right? They come into the room, they say, I don't understand this thing that I just saw. This doesn't make sense to me. I feel like that's not the way that it should look. And when it comes to the law broadly, especially constitutional law, I often counsel people it is important from the get-go to zoom out more than to zoom in, right? The facts are important. The facts will make a difference to the ultimate determination. But the system becomes important, because in the Constitution and in constitutionalism, the theory of constitutions, it matters what not just the facts look like, but what are we actually talking about in the law? What is the realism that we're dealing with? What are the actualities that we're dealing with? And how does that tie back to fundamental concepts of fairness and justice? It's not always an easy thing to do because it's not our natural inclination. Now, I want to start with the Fifth Amendment, and I want to ask critically, and I'm not sure how many people here have spent a lot of time with the Fifth Amendment. I'm assuming enough time, especially. And let me guess, what part of the Fifth Amendment, if any part, have people spent any time looking at? Or is there something about the Fifth Amendment that stands out to people as being particularly critical when it comes to the Bill of Rights and constitutional kind of 101 when we're thinking about this with students? Because students definitely, I'll say this, right? And I just pulled up my chat to look at it. So most students won't come in too much about grand juries. That's not always the case, but it doesn't usually pop up too much. Double jeopardy, Roger, I love that because, and I could actually, note an incredible double jeopardy case came up a term ago that deals with the concept of the dual sovereigns. And students, I remember when I taught this actually to high school students, and they were falling out of their chairs thinking that this was the coolest thing, where there's a dual sovereignty concept that the state, i.e. Indiana, is different than this state, i.e. the federal government, and you can be prosecuted for the same action by both. And the double jeopardy clause does not attach. There was just a fantastic case on this a term before the last term, and they were just falling out of their chairs because they couldn't figure it out. And it talks about the monarchy and all these sorts of things and the crown, and it was a great case that everybody found very interesting. So definitely double jeopardy. But due process, I see Catherine, Abby, and Jill, due process, right? This grand, incredible pronouncement that we find in the Fifth Amendment that most likely, when it was put in there, didn't even attach the way to the drafters that it does to us today, right? The idea, the big trifecta, right, about life, liberty, and property, and the idea about how life, liberty, and property operate, both from a substantive perspective and from a procedural perspective. And I think that's always important to note, because the Fifth Amendment and the 14th Amendment as well do not say that you cannot be deprived of your life. They do not say that you cannot be deprived of your liberty, and they do not say that you cannot be deprived of your property. So this is, again, why I want to go back and always be focused on what the law is from a kind of big picture process perspective, because many people think that, well, it says that I can't be deprived of my property. Well, no, it says that you can't be deprived without due process. Now, as we all know, that's not always the case. There are certain things that you can't be deprived of. But this trifecta is an incredible piece of law. And I just want to keep people's mind on this. This is where we find in the Constitution, this is where we see written in a positive form, natural rights and human rights. And I'll explain more as we go along, but that's why I wanted to start with our little trifecta earlier about what the law is, because it helps us understand the trifecta we find in the Fifth and 14th Amendments, right? When it comes to life, liberty, and property. Now, obviously, the 14th Amendment looks a little bit different, right? What's the major difference, if anybody knows, between the Fifth Amendment and the 14th Amendment? Obviously, the 14th Amendment came about as part of the Civil War amendments, the 13th, 14th, and 15th. But the big piece is obviously exactly what you just said, Janet. The 14th Amendment was intended to not just apply to the states exactly, but also, of course, incorporate the Constitution against the states. So before the 14th Amendment, the First Amendment did not apply to Indiana. It didn't apply to New York. In fact, there were lots of speech codes. There were lots of prohibited speech laws in different places. And Janet, if you might know this, only because you had that answer right, is the Bill of Rights fully incorporated today? If anybody knows that. No, exactly, right? So we even just had a big case last term about the Eighth Amendment, and it's an incredible transcript. I shared it with my students. It's called Tim's versus Indiana. And if you read the transcript, the justices literally are just looking at the lawyers wondering, while we haven't incorporated this yet, of course we're going to incorporate this particular part of the Eighth Amendment. It's an assumption in many ways, except, there are pieces that probably will not end up incorporated. There's pieces of the Seventh Amendment. There may be some other pieces too. This is very important because this is the first time that the states now have to recognize constitutional kind of concepts, especially within the Bill of Rights. Now, I want to think about these again in the context of what we learned earlier. These words are very simple, but they have a lot of power, right? Life, liberty, and property, especially life and liberty, right, have a lot of authority in the American lexicon. There is a very important attachment that we seem to have developed over the last 250 years to this concept of especially liberty, right? That word is a very, very powerful word. And I want us to be mindful of that because we've essentially, like I said before, baked an entire area of law, almost all of natural and human rights, into 3 words found twice in our Constitution. Most other constitutions do not do this. If you do a comparative analysis, most constitutions spell a lot of different things out. So you can look at how different countries have managed this similar question. But we have decided over time to, instead of amending or changing the Constitution, to just throw more concepts of fundamental rights and fundamental liberties into these 3 words in 2 different clauses. And again, I want to think about and always be mindful of how that looks from a realism perspective. Obviously, there's a big realism perspective that comes into, there ties into a fundamental, a natural human rights perspective, and then obviously a positivism perspective. So let me ask everybody this. Why is this such a highly contentious, debated, and discussed area of the Constitution? Why is this a point that always comes up all the time, especially when students have a look at current events? Why is this where so much of the rubber hits the road and entire courses are designed around these 3 words and these 2 amendments? And particularly, you can do a whole course on the 14th Amendment. What is it about this that is so important to us historically? It's so important to students when they're studying civics and they're studying constitutional theory. What do we think really becomes critical here? Is it because this is an area, I'm curious to see what people think, is it because this is an area that packs a lot into a couple different words and therefore makes it more subject to interpretation and question? Is it because it feels like it involves core concepts of what it means to be a part of the American experiment? What is about this that really seems to hit home all the time? And Catherine, I like that because we're thinking about the deprivation of rights based on gender, national origin, color. Absolutely, right? So we have to always be mindful, especially in this larger context of what the law is, that everything that we're looking at is, of course, going to be a reflection on the times it's written, and of course, is going to be reflective of what people were thinking and doing at the time that things were written. So you're absolutely right. When we're thinking about how things have changed fundamentally over the last 250 years, it becomes really important to think about, well, where in the Constitution have we changed our approach? Where in the Constitution have we thought differently? These 2 words in the Declaration, we do see these. You're absolutely right. There's no question that, and Andrew, you point this out, there's literally no question. This is a American concept at its core, liberty. There's no other place, no other constitution, there is no other fundamental document in the entire world that attaches so much to this concept of liberty. And so you're right. To pack so much into one word necessarily by definition means there's going to be a lot of discussion and interpretation of that word. So there's no question about that. And again, that's super highly specialized because as in our country, we attach so much there and we put so much there. It's real. People can feel it. Yep, that's right. It's very real because this is something that comes up all the time when people have a deprivation, whether it is criminal law, which is entirely constructed around a deprivation of either life in some way, liberty in some way, or property in some way, or the numerous different ways in which this attaches from a civil perspective. So absolutely, it's very real. And this is where people feel that they should be able to go to get a remedy. And it is very relatable. I think in many ways, one of the things that makes civics and a constitutional civic education very special and different is, unlike math and unlike science and engineering, and it's not that I don't love those subjects, but our students come into our classrooms every day having learned civics in real life. It's very, very different. Things have happened to them in real life that they are trying to understand, and they come into our classroom trying to understand. And it can be good things and it can be not good things. And so there is a very relatable element about this to students because they will have something that's happened in their family or to a friend. Something will relate back in a way that does not happen the same way in most other subjects. And so that's a great point, Abby, something we should always be conscious of. It's why this is such an incredible area to all be able to teach in. Now, I want to think about, and actually, Catherine, I'm so glad to see that point as we go into this. I want to think about a little bit of background on the 14th Amendment's Equal Protection Clause. And I especially want to think about this with what you just said, Catherine. I especially want to think about this with what you just said. So I am actually going to show us tonight what I call the Justice Scalia approach to understanding the 14th Amendment. It is not always the way in which people approach the 14th Amendment, but I actually think it may be one of the most unique ways to approach it because it is a textual, original public meaning analysis. So it is actually pretty middle of the road, maybe a little bit conservative of a way to look at the Equal Protection Clause. And I think this is going to surprise people. And I'm glad it will, because I think Catherine goes right to your point. So we actually find the Equal Protection Clause and the discussion of it coming out of Ohio in 1851 in the Ohio Constitution. And we can see here what that clause looked like. It's outlined here kind of broadly so that we can have some of the contextual background and analysis. It also comes out of somewhat of Iowa's 1857 Constitution. This idea that there should be a uniform operation of law, that there shouldn't be what is seen as class legislation. Let's remember from a realistic perspective where the 18th Amendment is coming from, right? Excuse me, the 14th Amendment is coming from. It's obviously coming from the Civil War, right? We have a fundamentally altered view of the relationships between the federal government and the states. And we have a fundamentally altered view, a very pure in many ways view of what this is supposed to do. And you can see in the 13th and 14th and 15th Amendments, there's an incredible intent to change that fundamental compact that exists between us and government, right? It comes back to those relationships. But you're absolutely right, Catherine. It's a huge shift. This is not a small shift. To go from this very antiquated concept of liberty that existed when things were passed, and to move wildly forward to start to look at, well, what about the Equal Protection Clause is unique? What about the Due Process Clause is unique? These are big shifts, and that's why I wanted to go back to almost an original meaning of the 14th Amendment. This becomes important when we look at civil rights and some of the recent cases that have come up, because these arguments have actually been working at the US Supreme Court. Now, Charles Sumner, who actually was one of the people that helped put the 14th Amendment together, put into the case Roberts v. City of Boston, arguing that, and I love this quote, and I use this all the time because I think it's really incredible to note, and especially Catherine, let's think about, and everybody else, let's think about, what year is it today? It's 2020. So in 1849, when the author of the 14th Amendment, or well, I should say one of the authors, but really one of the main key people in the 14th Amendment analysis, puts this together, he's immediately talking about what this is intended to remedy, right? And it is not perfect, and I do not mean to argue that this was perfect, but I do think it is important to note that 1849, this is why I didn't go to, this is why I went to law school. So that is 153 years ago. That, I think that's right, or no, 171. Yes, see, that's why I don't do math. So it is old, right? This is a long, long, long time ago, and people wouldn't necessarily realize that in 1849, we are already having these really forward-thinking views on the Equal Protection Clause. And yet I would probably ask, if I asked everybody here, have we gotten to this point? Have we realized this idea of what the clause means? I bet most people would say, no, we're not there. So I think that's important to recognize as we look at it through this lens. Now, more background, because I think this is still critical, right? When the Equal Protection Clause was even introduced, even when it was introduced, right here, right when people are talking about the 14th Amendment, the public debate, again, is extraordinarily different than the way we look at this amendment today. Very different. This idea of, again, class legislation, the breaking down of the caste system, that there shouldn't be different treatment of people based on characteristics. That's really important for the Equal Protection Clause, right? The idea that liberty is important, and we'll see even today that liberty is important, but equality is also important, and they are not the same. And I think we have to be conscious of how, over time, they have been seen as not the same. And I think that that's important, again, coming into this 14th Amendment analysis, again, always being mindful of our kind of trifecta of what the law is. So if we really were to credit original meaning of the 14th Amendment, here's really what it was intended to do, like we were just saying. And this is a very different view than how we see this today. And again, I bring that up because I think it's important from a realistic perspective to see what was the amendment intended to do, what does it really do for a natural and human rights perspective, where does that leave us from a positivism and the positive creation of the law, which is supposed to be encapsulated in the original public meaning framework, which again is the Scalia framework, and then the realism of where we are today. Now, we all know this, right? There are certain things that have been found to be substantively untouchable in the Constitution, right? Substantively, you cannot affect certain rights and responsibilities under the substantive due process framework of either the 5th or 14th Amendment. Again, this is that packed into the liberty word. This is what's packed in to the idea of life. So these concepts are so central that they cannot, without a compelling reason, be procedurally taken away. So the idea of this also is not foreign constitutionally. I'm going to ask a question, and I'm curious. I bring this back again to our fundamentals, but at the same time, I put up the 9th Amendment. Has anybody here ever taught or had a student bring up the 9th Amendment? Ever? I'm sure everybody's thinking, and then everyone's thinking, wow, no, that one never comes up. Students don't often talk about it. It doesn't really come up in cases. There are some scholars that would argue that, yes, it was, Andrea. That's absolutely right. It was most certainly in that case. So that's great. And Roger, I love that. Nope. And you know why? Because it's such an interesting enigma. If you looked into the history of why it was put in, and you look at the original 17 proposed possible amendments that got whittled down to 12, that got whittled down to the 10 that we see today, when it comes to the Bill of Rights anyway, there is an understanding that there are certain things that are not enumerated, that are so fundamental that they cannot be necessarily put into words. And this is a very interesting concept, and this is very important from a 14th Amendment analysis. Something I always want us to be conscious of, because if you were to ask even people that take and do this all the time, and they look at the Constitution, you get to the 9th Amendment and you say, oh, that looks really nice. But what does it mean? How does it fit in to the 14th Amendment? Remember, they all kind of talk to each other in this interesting way. But Roger, I'm so glad that you said no, because I think this is an area that is really special. I've always been surprised when students bring it up. I'm always impressed. It actually comes up in We the People a lot. I've definitely sat on nationals judging before assuming this job. And it has definitely come up with students because I think they like it, because it is just so interesting. And you're absolutely right, Andrea, it's an anti-federalist amendment. That is exactly where you get this concept from Virginia, right? And this push from Virginia. But to think about where that comes to today is really unique. And some people think it's dead letter law, but I think it's hard to see that when you look at the substantive due process question. Now, this comes up in cases, right? Substantive due process absolutely exists and is now something that the Supreme Court recognizes. So whether it's this privacy right that sort of exists, and you see it in Griswold v. Connecticut, and privacy sort of is a 9th Amendment question, sort of is a 4th Amendment question, sort of is this 5th and 14th Amendment concept. I note that because we start to see these, and people have heard this term, I'm sure, before, the penumbras that exist between constitutional rights and theories, but they fundamentally come back down to that there are substantive things that cannot be abridged, even that they may not be fully written in the text. Same with the right to engage in intimacy, Lawrence v. Texas. We see no question that Justice Kennedy in that case finds that there is a fundamental right to engage in intimacy that cannot be abridged by the state. And it's not in the Constitution per necessarily the words, but it's in the 14th Amendment, and states can't abridge it. And it kind of is left there, again, this liberty right, but even more fundamentally, this human right, packed into that word. Same with the right to marry, right? We see in Loving versus Virginia, the right to marry a spouse, no matter the other spouse's race. We see in Obergefell v. Hodges, the right to marry your spouse, no matter their gender. This becomes very important. Again, you see a substantive due process argument that is made and adopted by Justice Kennedy in Obergefell, where the court says that you really can't interfere with some of these fundamental rights, even if they're not spelled out necessarily in the Constitution, and were not even spelled out necessarily at the time that the 14th or 5th Amendment was written. And again, it comes back to some of those ideas of what does it really say and what does legal realism teach us? Now, similar but not quite the same is the way that we look at that equal protection clause again. Now, I want to note something as we start to think about this, right? We talked about class legislation. The equal protection clause has been interpreted over time to, instead of guarding fundamentals, it instead is essentially looks at different classifications looks at different scrutinies. I'm sure we've all had to think about the scrutiny tiers at some point or another, and then attempts to look at whether the government can make differentiations based on those classifications or not. This is very interesting because, as you can tell, and as I'm sure we all know, this is not necessarily the original intent of the amendment. This is not necessarily the original intent of the clause. And I think it's very interesting and important to know that the substantive due process protections that exist under the Fifth and 14th Amendments very often guarantee equality, where the Equal Protection Clause very often does not. Why am I focusing on that very quickly? Because students, as they rightly should, come in and they point to their Constitution and they say, it says equal protection of the laws. That's where equality exists. And again, I want to take us back to, well, what is the law? And yes, that's a good argument. Yes, students should make that argument. Yes, lawyers should make that argument. But that's not necessarily the reality of how the clause and the amendment has been interpreted. Instead, over time, it's far more critical to look at what some of the fundamentals are under the Constitution and the substantive fundamentals, and how that looks, as opposed to, well, you're treating me differently than this other person. And I can just give a little antidote. One of the things that we uncovered when I was working on the book I just finished is that it was, as much as the equality argument in the marriage equality movement was the one that everybody put forward for many, many, many years, it actually did not make the same fundamental difference when it came to the states that passed marriage equality and people adapting and adopting marriage equality as a fundamental rights argument did. And it's really interesting to see how much, as I guess, as a society, we like the word equality, but what it legally protects, or what it legally means, or has the legal effect of, is very different in our ethos than the idea of fundamental liberties, fundamental rights. And I think that's an important distinction to think about, because students very rarely will come in and say, my liberty clause has been violated, when it's possible, actually, that it has, that there are some fundamental rights and liberties in the way in which the government operates, versus why am I being treated differently? And I just want to note that, because I know it comes up all the time. Now, race, religion, national origin, famously with RBG, gender, and alienage have all been found to have some sort of higher tiers of scrutiny and classifications when it does come to the Equal Protection Clause. Sexual orientation still is kind of unsure. Some places it's seen on equal footing with gender. Some places it's seen on equal footing with maybe gender plus. It doesn't necessarily make a whole ton of legal sense. And actually, it's Justice Thomas that has written in some dissents that has questioned, why in the world do we look at the Equal Protection Clause this way? Why is it not much more of a bright line rule when it comes to the way it's interpreted? And I just want to note that, because I think it's actually very interesting. He's not who I would have anticipated and or expected would think that way, but it actually is often him that looks at this in a very unique lens. Now, the Equal Protection Clause has been absolutely critical, even with that, right? School segregation, Brown v. Board. Again, Loving is a dual 14th Amendment case. So it is a fundamental right, and it is also prohibited under the Equal Protection Clause. I just mentioned Ruth Bader Ginsburg's major decision that she's most probably well known for as a justice, United States v. Virginia, when it comes to women in public colleges, right? So I don't want to say that the Equal Protection Clause doesn't have teeth. I don't mean it that way. But I do want us to be realistic about how to approach it when we're thinking about it and teaching it. in the 14th Amendment, especially when we are looking at social justice and various different ideas about the way we're looking at talking with our students about how this actually operates. Same with same-sex marriage. I'm going to talk about it a little bit more closely in just a second. But yes, the Equal Protection Clause plays a role in Obergefell, but it's not as great of a role as people might think. So like I said, when it comes to these clauses, it isn't always just one or the other. And as important as they both are, they do work much more in tandem than one might think. So I've quoted here from the decision when it comes to the substantive due process rights, and Justice Kennedy looking at how this is a fundamental right and that there would be you have to show a compelling public interest to abrogate that fundamental right. And instead of accomplishing this, and instead of making that something that was arguably okay, right, the justifications for excluding same-sex couples were speculative in the defense of the marriage argument, and then also looking at responsible procreation tailored to only exclude essentially lesbian and gay couples, and looking at the way in which children are raised, court said that's not fundamental enough to really adapt and understand how this works under the Substantive Due Process Clause. Now, there we go. Similarly, it's not just that, it also is an equal protection question. So the right of same-sex couples to marry, it's promised by the 14th Amendment, is derived also from the equal protection. And looking at Justice Ginsburg and the way in which Justice Ginsburg pushed Justice Kennedy to make sure to include this argument was something that had been done in Lawrence and done in Loving, and Zablocki is the old marriage case. When it comes to interpreting the Equal Protection Clause, the court has recognized that new insights and societal understandings can reveal unjustified inequality within our most fundamental institutions that once passed unnoticed and unchallenged. So it's not even so much that there's this actual argument between how does the Constitution function today, how did it function when it was essentially written, how did the amendments function today versus when they were essentially written. I think that that's a very simplistic way of instead looking at the broader picture of, well, what rights are fundamental rights? How have we decided to organize ourselves as a society, right? Coming all the way back to that. And then critically, the realism that comes with understanding that that changes over time, that there's a different understanding of what liberty means over time, of what the Equal Protection Clause means over time, and whether that fits the original meaning or not is something that I wanted to weave into our discussion today as we're starting to think about this, right? Now, it comes all the way back to what the law is. And why is this? Because the 14th Amendment, the Equal Protection Clause, the Due Process Clause, this is where students often, like we said before, come into the classroom and want to think about, well, how does this really work? And that's not always an easy answer, because it's not always easy to explain to students, right, why it may feel like there's some sort of natural right or human right that should attach to something, but yet the law has yet to recognize it the way that they may think about it. And obviously, legal positivism and legal realism are highly influenced by elections, right? Legal realism judges are often elected. If they're not, they're appointed by somebody who has been elected. Prosecutors are generally elected, except on the federal level, they are appointed by somebody who is elected, right? The state legislature is elected. Your local representative is elected. The legal realism that attaches to each of those offices is crucial. It is critical. And so students frequently will not be thinking about the system as a system, but it's really important to think about the system as a system, because that's the only way you know where to approach some of the questions that come up under these big picture concepts that don't always make sense in the instance when we're looking at a particular fact pattern. And it doesn't always make sense why when people will make certain claims under the Equal Protection Clause, or people will say, well, how does this make sense from a constitutional perspective, looking at the big picture analysis and looking at how these all interact. Now, going forward, I think it's important to think about a few different things. And I want to make sure that I leave time for questions. So I'm kind of going a little bit faster than I wanted. But the interplay between substantive due process and equal protection is truly remarkable. It will be fundamentally altered by the loss of RBG. She was the center figure on the power of the Equal Protection Clause. She is the one that really pushed the Equal Protection Clause from almost an original intent perspective in a different way than most other justices. In fact, if you look at some recent opinions that some of the justices have written, some of them instead, and we don't have time to talk about this tonight, but some of them instead have focused on the Privileges and Immunities Clause as a place that fundamental privileges and fundamental immunities from the government should exist. That hasn't historically been the way that the Fifth or 14th Amendment has been looked at. It hasn't historically been the way in which the Constitution has been seen to be a fundamental protective document. And of course, then how do these concepts apply to current and future questions, right? We're always going to be dealing with students that come in with current questions, but we're always going to have future questions too about how these relationships operate and how these relationships work. And I can't tell anybody here why due process may have won out the day versus equal protection may have won out the day versus the Privileges and Immunities Clause, which in some ways is almost even more beautiful from a literary standpoint than even the Equal Protection Clause. And yet it's almost a legal nullity. And I can't necessarily answer why that's evolved that way. That's a realism question. But I do think it becomes important when we're thinking about how we're teaching our students, because they will come in with these questions about these clauses and these ways in which these actually attach to the real life experiences they're having. And these are the kind of questions that I think are going to continue coming up going forward when it comes to these particular areas in these amendments. Now, I want to stop sharing for a second because I want to make sure that I leave, because that's a lot of information in a very short period of time. And I see that I did leave a couple minutes. It's good. So I want to see what people think about what we just discussed. And I'm curious to hear actually what people's students have asked about this area and what have students brought up when it comes to the Equal Protection Clause or the substantive due process concepts or liberty. I just was actually Zooming with a class recently, and I was bombarded for an hour and a half by students asking through the presentation out, students asking about this. So I know this comes up, and I'm curious, what are the kind of things that you've heard from students in your classroom about fundamental liberties or fundamental rights or equal protection questions? Or what are some of the things that they've brought up that you've thought to yourself, well, that's an interesting one. What are those kind of things that either key in your mind or strike anybody as being particularly in the front of kind of the way you're thinking about this particular area of law, if anything? And I'm also happy, of course, to answer other questions that may have come up, because we've just gone through a lot.
So I got a litany of things maybe.
Sure. Roger, go for it.
You had said something about making sure that they know the system is a system. And that's super hard these days with the 15, 16, 17-year-old youth, when teaching them that this system is set up for them and it's not. It's almost, you know, I'm more relevant telling them about the playoff baseball 7th inning rules. You know, that's about as relevant to them as all these systems that we use, you know, all in persons and equal and liberties and rights. A lot of them are like, yeah, not real relevant. Touch on that if you can.
Sure. Well, I think that's, you know, that's really interesting because, you know, it's often, and especially at the moment, and you know, I will be the first to say that everybody on this Zoom is an incredible human, because teaching over Zoom, even if it's part-time or if it's full-time, has been an extraordinary journey for myself as well. And it is not easy. It takes a whole new set of skills. And Roger, I'll be the first to tell you, I had a couple 17 and 18-year-olds in my class, my last class I just taught at Columbia, and whoa, that was a humongous shift, not because of their age even, but because of what their age showed me about teaching on Zoom and how different that was versus my college-age students or my graduate students. So you're absolutely right. Oftentimes, students don't immediately think of how this has such a profound, or could have such a profound impact on them. What I've noticed is, you're right, oftentimes if the Constitution does come up, it comes up in the context of something about criminal law, right? So something about the Fourth Amendment, something that somebody's seen on the news about the interplay between the branches of government, right? Or other things that may seemingly be high profile and high, you know, of high media newsworthiness over the First Amendment. I know that always is something students love. I know we've all probably had a student come in and say, you know, something about how they have the right to speak, and we all know that that's not always the case, which is always a shock, right, to students when they learn that that's not necessarily true. But, you know, I think what I've found, Roger, is, and I know this has probably changed for each of us as we're dealing with teaching at the moment, is when these things do come up and students feel strongly that there's something wrong here and something isn't right with this fact pattern, they can't always put their finger on what it is. And I know that because I've seen it myself. But there's something really unique about that internal feeling that there's something really wrong here, and then translating that to, well, how do we look at that from a constitutional perspective? So like Andrea put into the chat, it's applied very literally for some students. They think, well, life, right, and liberty from a from a due process standpoint means, well, how could this possibly happen to somebody? And how does that process look? And what are the ways in which that process can be flawed, right? And how can that process be flawed? I know one of the big questions that I myself pivoted on this past summer was one of the first times that I've spent nearly as much time on the 13th Amendment as I ever have teaching constitutional law for 10 years. And I very quickly had to pivot and spend an entire class session on the history of the 13th Amendment because of things that had come up in the real world. And I wanted to make sure we covered them from a constitutional standpoint. And so you're absolutely right, both Roger and Andrea, there's always going to be this literal component that we have to think about. But if it was that literal, if all it was words on a page, then we wouldn't have anybody around to interpret them, and we could plug all of this into a computer. And I've definitely done this scenario with students. I've definitely done this scenario with others. Nobody likes the idea of plugging these things into a computer. There's something very visceral that people react to when it comes to thinking about, and there's actually studies about this that have been done about looking at how would technology adapt, and even in the criminal law context, there's technology that people have tried to adapt to concepts of life and liberty. And so it's that nuance, that balance that I think is really hard to necessarily get to, but it's where I always try to push at least my students to get to a point of understanding. It cannot be as simple as a literal reading of the text. And if it was as simple as that, we would have a very different way that people would look at constitutional theory. And in many instances, and again, I often will say this, I think it's incredible to think that there are countries like New Zealand and countries like the United Kingdom that don't have anything to apply literally because their constitutions don't even exist on paper the way that we think of ours on paper. And students really find that to be interesting. And I wouldn't necessarily, do that in a 8th grade class, because that could really open up an interesting debate. But it is really special that that's possible. And mind you, that's a functional democracy of 800 and plus years. So there's something possible there. It's just very different. Again, it comes back actually to that legal custom, as well as tying all of these legal concepts together in the way in what the law actually is. I know that was a long-winded answer, I think, to two questions.
No, thank you, and I have a lot to unpack from that. I appreciate that.
No, I'm trying. No, and believe me, like I said, I'm trying to pack a lot of class into a very short period of time to give people at least a spark as to how this might look.
Yeah, no, I really appreciate that.
Mm-hmm. Of course. Are there other questions as we have a couple minutes left, or other things that have come up while we've been going over anything today? I think we have like 5 minutes. Or other things that students have brought up that have come up, especially considering how everything looks at the moment.
I'll throw one at you, Christopher. What's a legal response when a student just wants to say that's not fair?
The law isn't always fair, unfortunately, and the law is responsive to society, and society is a social compact that includes elections and includes decisions. I know I can actually, Tim, this came up on a Zoom I had with another class recently, where people were very, very, very focused on the presidency. And yet, we all should remember the presidency is Article 2 of the Constitution. It is not Article 1. It is Congress where power resides in constitutional law land. It is Congress that power resides in, a limited power, right? It's a limited federal government. So that limit, as designed, is to be contained specifically in the first branch. And I know right now lots of students have been asking me, what about the vacancy in the court? And how does that look from the Senate's perspective? And can they do this? And I frequently try to turn my students' attention back to two different things. One, looking at the structure of the way in which this is put together, and looking at the way in which very few people will pay attention to the first branch, when that's probably where we should be paying far more attention, right? If Congress was passing lots of statutes, if Congress was acting to do that, if we were paying closer attention to the legislative process, the second branch of government becomes less important. And the third branch of government actually becomes less important because we're not hanging so much on the concept of liberty or equality. We're instead hanging it on the concept of a democratically elected body that is to be responsive to the democratic electorate. And second, I know there's always so much attention at the federal level, but everybody here knows the most important person that's elected in your life is your local legislator. They are by far more impactful on your day-to-day life, on whether you have water, whether you have a sewer system, whether there's a stoplight at your school, whether the bus makes it around. And I think in many, many, many ways, students don't always think about that until they start thinking about all of the ways in which they interact with the world. And that's often something that I know there's always more media attention at the federal level, but it is not usually the federal person, even if they have a lot of attention, that has the greatest impact on their lives. And I see what Roger said, and Andrea, I see, can the due process and equal protection of current demand for reforms? Andrea, I would say this. I would have said, interestingly, possibly a year ago. And now, the more I think about it, the more I've been really impressed with 13th Amendment scholarship that's come up over the last couple of months. There's been some incredible 13th Amendment scholarship on this exact question. And it's always interesting to see if you can think of and find another amendment that might address certain systemic issues that may exist, and find them in ways that could be argued based on the text in a way that hasn't been argued before. And that's what a lot of this scholarship actually looks like at the moment. And so I'm not saying no. I'm just saying I would think more broadly now, because I think the conversation allows for us to think more broadly now than just the 14th Amendment, especially since Congress has incredible power under the 13th Amendment, incredible authority under the 13th Amendment. And I think that's something that people might see exercised differently depending on what Congress looks like in the next term. And it also includes the rationale behind criminal law with regards to fairness. Absolutely true. There's an entire plethora, actually, in the legal realism and legal positivism world that discusses rehabilitation, that discusses the criminal concepts of right of punishment. And a lot of actually those theorists are the ones that actually form the basis for what is the law. It's actually a lot of those theorists that have explored that over the years. But I want to note that that's a piece of that puzzle. Yet, I think it's important to be cognizant of that part of the puzzle because it's where their theories come from. You have to always be mindful. It's like Thomas Hobbes, right? Why does the Leviathan look like the way it does? Well, history was informing the way he was looking at security of the state and the creation of the state. And Andrea, I'm so glad for you to say that because that's what I said too. And I've had so many students now do in-depth projects on the 13th Amendment. I know that we're actually doing a big Zoom in a couple weeks about some of those questions on the 13th Amendment at the center that's open publicly because it's that new an area at the moment. And how shocking is it that that can be a new area this many years later? But I hope that's actually something people got from this is how incredibly both complicated, but there's a beauty in the complication that comes with understanding a constitution like ours, which is short and, kind of to the point, and yet contains an incredible history for a country of our age.